My name is John Whyte. Currently I hold the Ariel Salos Chair in Human Rights at the College of Law at the University of Saskatchewan, but I have been a law teacher and a public servant for 4 decades in Ontario and Saskatchewan and some other places in Canada and the world. But as I say, right now I'm at the University of Saskatchewan. Now I'm going to talk about Section 1, which is, not surprisingly, the first section of the Charter. And it says that the rights and freedoms described in the Charter of Rights and Freedoms are guaranteed subject only to limits that are prescribed by law and can be demonstrably justified in a free and democratic society. The important thing to know about Section 1 is that it is a result of a tremendous, I suppose, schizophrenia or anxiety in Canada at the time of the making of the Charter. And that arose from our long parliamentary supremacy tradition, the idea that as we ordered society, it was the legislature that chose our schemes of distribution, our schemes of regulation, and our schemes of liberty, not the courts. And to move to an constitutionally entrenched charter was to assign to courts a role which before that they had not had, and people were very anxious about it. They felt that there would be a loss of political authority, or the political authority of the legislature would be transferred to courts to decide how it is we should be governed, how it is we should be regulated. And 2 sections were put in the Charter. The one was Section 1, this one that says the rights are limited, and this other one was Section 33, which said that rights could be overridden. Now Section 33 is gone from our constitutional practice. I'm not saying it's gone from the text, just something that we don't use anymore. So our interest in preserving or finding some space for parliamentary and legislative choices about how we order society is really bound up in Section 1. And Section 1 is very, very vital, very much alive, and it is applied in almost every charter case. The thing that you should need to be aware about Section 1 is that it has by and large been used as I would say, a very big weapon to preserve parliamentary and legislative choice. The choices that legislatures make about the balance between individual liberty and due process and equality and the needs of society as a whole, public interest, or the idea of the capacity of everyone. And arguably the Charter of Rights was to put a check on those legislative programs when they were too costly for individuals, too insensitive to individual circumstances, too indifferent to minority communities. And by and large the Charter has jurisprudence, that the Charter's application to the courts has reflected that tension. But on the other hand, there has been a tendency over the 30 years of Charter's life to give more and more scope to legislative choice through more and more generous application of Section 1, generous in terms of the needs of legislatures, not the needs of claimants. Now that's a generalization, and there could be counterexamples. There are thousands of charter cases a year, and there could, of course, be counterexamples. But by and large, Section 1 has been interpreted to give a fairly generous scope to legislatures to order society over the charter protections. And perhaps that's unfortunate.